Question 1. Governance review demonstrates that a property manager in New South Wales is implementing a tenant screening process. Which of the following approaches best aligns with best practice and regulatory requirements for tenant selection in NSW? Option A. Inquiring about a prospective tenant's family size and whether they plan to have children soon. Option B. Asking for details about a prospective tenant's medical conditions and any personal support networks they may have. Option C. Making subjective judgments about a prospective tenant's reliability based on their initial presentation and perceived lifestyle. Option D. Verifying identity, obtaining rental references from previous landlords, checking credit reports through a licensed tenant database, and requesting proof of income. The correct answer is D. Verifying identity, obtaining rental references from previous landlords, checking credit reports through a licensed tenant database, and requesting proof of income. Explanation. Scenario analysis. This scenario is professionally challenging because it requires balancing the landlord's legitimate need to select a reliable tenant with the tenant's right to fair and non-discriminatory treatment under NSW law. The property manager must navigate the complexities of gathering relevant information without infringing on privacy or engaging in prohibited practices, all while ensuring the property is leased to a suitable individual. The risk of contravening the Residential Tenancies Act 2010, NSW, and the Anti-Discrimination Act 1977, NSW, is significant if the screening process is not meticulously designed and executed. Correct approach analysis. The best professional practice involves a structured and transparent screening process that focuses solely on criteria directly related to a prospective tenant's ability to fulfill their tenancy obligations. This includes verifying identity, assessing rental history through references from previous landlords, checking creditworthiness via reputable tenant databases, and confirming financial capacity through proof of income. This approach is correct because it aligns with the principles of fair housing and the specific requirements of NSW tenancy law, which permit landlords to assess a tenant's suitability based on objective factors such as their capacity to pay rent and their history of responsible tenancy. It avoids any consideration of personal attributes that are protected from discrimination. Incorrect approaches analysis. One incorrect approach involves requesting information about a prospective tenant's family status or plans for children. This is a direct contravention of the Anti-Discrimination Act 1977, NSW, which prohibits discrimination on the grounds of family responsibilities and sex. Such inquiries are irrelevant to a tenant's ability to pay rent or maintain the property and can lead to discriminatory selection. Another unacceptable approach is to ask for details about a prospective tenant's medical history or any disabilities. This is also discriminatory under the Anti-Discrimination Act 1977, NSW, and is irrelevant to tenancy suitability. Furthermore, making assumptions about a tenant's reliability based on their age or appearance, rather than objective evidence, is unprofessional and potentially discriminatory. This relies on subjective biases rather than factual assessment, which is contrary to best practice and legal requirements. Professional reasoning. Professionals should adopt a decision-making framework that prioritizes legal compliance and ethical conduct. This involves 1. Understanding the specific legislative framework governing residential tenancies and anti-discrimination in NSW. 2. Developing a standardized screening checklist that focuses on objective criteria directly linked to tenancy performance. 3. Training all staff involved in tenant selection on prohibited grounds of discrimination and best practices for information gathering. 4. Documenting the screening process for each applicant to demonstrate fairness and compliance. 5. Regularly reviewing and updating screening procedures to reflect any changes in legislation or best practices. Question 2. Process analysis reveals that a real estate agent in rural New South Wales, NSW, is listing a property that includes a substantial dwelling, extensive outbuildings typically used for farming, and approximately 50 hectares of land actively used for grazing livestock. The vendor has indicated a desire to sell to someone who appreciates the rural lifestyle, but has also mentioned that the land has historically been used for agricultural purposes. What is the most ethically and legally sound approach for the agent to market this property? Option A. Market the property primarily as a lifestyle property to attract a broad range of buyers, without delving deeply into its specific agricultural classification or zoning. Option B. Accurately classify the property based on its primary use and features, considering its agricultural components and zoning, and market it transparently, disclosing all relevant aspects of its agricultural potential and any limitations. Option C. Advertise the property exclusively as a residential property with a large backyard, downplaying its agricultural infrastructure and land use. Option D. Focus marketing efforts solely on the property's potential for subdivision and development, disregarding its current agricultural status. Correct answer is B. Accurately classify the property based on its primary use and features, considering its agricultural components and zoning, and market it transparently, disclosing all relevant aspects of its agricultural potential and any limitations. Explanation. Scenario analysis. This scenario presents a professional challenge due to the potential conflict between a client's stated intentions and the agent's ethical and legal obligations. The agent must navigate the nuances of property classification in New South Wales, NSW, and ensure that the property is marketed and sold according to its true nature, adhering to the Property and Stock Agents Act 2002, NSW, and its associated regulations. Misrepresenting the property type can lead to significant legal repercussions, damage to reputation, and harm to consumers. The agent's duty of care and disclosure are paramount. Correct approach analysis. The best professional approach involves accurately classifying the property based on its primary use and physical characteristics as defined by NSW legislation and common understanding of real estate types. This means identifying whether the property is predominantly residential, commercial, industrial, or agricultural. If the property has mixed uses, the agent must determine the primary purpose or disclose all significant uses transparently. For a property with a dwelling and significant land used for farming, the agent must consider if it falls under agricultural zoning or if the residential component is secondary. Consulting relevant local council zoning information and understanding the definition of agricultural land under NSW planning laws is crucial. The agent should then market the property accurately, highlighting its primary classification while also disclosing any secondary uses or potential. This aligns with the agent's duty to act honestly and in the best interests of the client, while also complying with disclosure requirements under the Property and Stock Agents Act 2002, NSW. Incorrect approaches analysis. Marketing the property solely as a lifestyle property without clearly defining its agricultural potential or limitations is misleading. This approach fails to provide potential buyers with the necessary information to make an informed decision about its suitability for agricultural purposes, potentially breaching disclosure obligations. It also risks misrepresenting the property's primary classification if the agricultural use is substantial. Advertising the property exclusively as a residential property with a large backyard ignores the significant agricultural infrastructure and land use. This is a direct misrepresentation of the property's nature and could lead to buyers purchasing with incorrect expectations regarding its agricultural viability or zoning restrictions, violating the agent's duty to provide accurate information, focusing only on the potential for subdivision and development, without acknowledging or accurately describing its current agricultural status, is also problematic. While development potential might be a selling point, it does not negate the current classification and use of the land. This approach prioritizes a speculative future over the present reality, potentially misleading buyers about the property's immediate characteristics and regulatory status. Professional reasoning. Professionals should adopt a systematic approach to property classification. This involves 1. Understanding the definitions of different property types, residential, commercial, industrial, agricultural, as they apply in NSW. 2. Thoroughly inspecting the property and its surroundings to assess its primary use and features. 3. Consulting relevant local council zoning maps and development controls. 4. Identifying any potential for mixed use and determining the dominant classification. 5. Disclosing all material facts about the property's classification, use, and any restrictions or potential to prospective buyers. 6. Acting with honesty, integrity, and in the best interests of both the client and the consumer, in accordance with the Property and Stock Agents Act 2002, NSW. Question 3. The performance metrics show a consistent trend of quick sales for properties listed by your agency in Sydney, New South Wales. A vendor, eager to finalize a sale quickly, has just accepted an offer on their property and is asking you, as their agent, to expedite the exchange of contracts, suggesting they don't need the standard cooling-off period and want to proceed immediately without it. What is the most appropriate course of action? Option A. Inform the vendor that the cooling-off period is a formality and can generally be disregarded if the sale is urgent, and proceed with the exchange. Option B. Suggest the vendor sign a simple declaration stating they wish to waive the cooling-off period and then proceed with the contract exchange. Option C. Advise the vendor on the statutory cooling-off period as mandated by the Conveyancing Act 1919, NSW. Explain its purpose and duration, and inform them of the legal requirements for a valid waiver, including the necessity of a solicitor's certificate, before proceeding. Option D. Proceed with the exchange of contracts immediately as requested by the vendor, assuming they understand their rights and are willing to forego the cooling-off period. The correct answer is C. Advise the vendor on the statutory cooling-off period as mandated by the Conveyancing Act 1919, NSW. Explain its purpose and duration, and inform them of the legal requirements for a valid waiver, including the necessity of a solicitor's certificate, before proceeding. Explanation. This scenario presents a professional challenge due to the potential conflict between a client's immediate desires and the legal requirements for a valid contract, particularly concerning the cooling-off period mandated by NSW legislation. A real estate agent must navigate this ethically and legally, ensuring all parties understand their rights and obligations. The agent's duty is to facilitate a compliant transaction, not to pressure clients into waiving legal protections. The best professional approach involves clearly explaining the statutory cooling-off period to the vendor, outlining its purpose and duration as stipulated by the Conveyancing Act 1919, NSW. The agent should then advise the vendor that any contract exchanged during this period is subject to the cooling-off rights, and that a waiver, if desired, must be in writing and meet specific legal requirements, including a certificate from a solicitor. This upholds the agent's duty of care and ensures compliance with NSW property law, protecting both the vendor and the integrity of the transaction. An approach that involves the agent unilaterally advising the vendor that the cooling-off period can be ignored or bypassed is ethically and legally unsound. This fails to inform the vendor of their statutory rights and could lead to a contract being voidable, exposing the vendor to significant risk and potential legal disputes. It also breaches the agent's duty to act honestly and professionally. Another unacceptable approach is for the agent to proceed with the exchange without fully explaining the implications of the cooling-off period or the process for waiving it. This demonstrates a lack of diligence and a failure to ensure informed consent from the vendor. The agent's role is to facilitate understanding of the legal framework, not to assume the vendor's knowledge or intent. Finally, an approach where the agent suggests the vendor sign a document that is not a formal solicitor's certificate to waive the cooling-off period is also problematic. This circumvents the legal requirements designed to protect consumers and could render the waiver invalid, creating uncertainty and potential legal ramifications for all parties involved. Professionals should approach such situations by prioritizing clear communication, adherence to statutory requirements, and ensuring informed consent. This involves understanding the specific legal obligations under NSW law, such as those related to cooling-off periods and contract waivers, and acting with integrity to protect client interests while maintaining regulatory compliance. Question 4. Risk assessment procedures indicate a potential for a rushed lease signing process for a residential property in Sydney, New South Wales. A prospective tenant is eager to secure the property and has indicated they are willing to sign the lease agreement immediately upon viewing. As the agent, you have the standard NSW Fair Trading Residential Lease Agreement ready. What is the most appropriate course of action to ensure compliance with the Residential Tenancies Act 2010, NSW, and uphold professional ethics? Option A. Hand the tenant the lease agreement and instruct them to sign it quickly, stating that it is a standard form and there is no need for extensive review. Option B. Encourage the tenant to sign the lease agreement promptly to secure the property, assuring them that any minor details can be clarified once they have moved in. Option C. Present the tenant with a brief verbal overview of the most important clauses and then have them sign the agreement, as they have expressed urgency. Option D. Provide the prospective tenant with a copy of the proposed residential lease agreement and allow them sufficient time to review it thoroughly, advising them they can seek independent advice if they wish, before proceeding with the signing. The correct answer is D. Provide the prospective tenant with a copy of the proposed residential lease agreement and allow them sufficient time to review it thoroughly, advising them they can seek independent advice if they wish before proceeding with the signing. Explanation. Scenario analysis. This scenario presents a professional challenge because it requires balancing the client's immediate desire for a quick lease agreement with the legal and ethical obligations to ensure the tenant fully understands their rights and responsibilities under New South Wales NSW residential tenancy law. Failing to adequately inform the tenant can lead to future disputes, breaches of the Residential Tenancies Act 2010 NSW, and reputational damage for the agent. The agent must act with integrity and uphold the principles of fair dealing. Correct approach analysis. The best professional practice involves providing the prospective tenant with a copy of the proposed residential lease agreement, which in NSW is typically the NSW Fair Trading Standard Form lease, and allowing them sufficient time to review it, ideally with the opportunity to seek independent advice. This approach directly aligns with the spirit and letter of the Residential Tenancies Act 2010, NSW, which mandates that tenants be provided with a copy of the agreement before signing and that they understand its terms. It upholds the ethical duty of transparency and fairness, ensuring the tenant is making an informed decision. This proactive measure prevents misunderstandings and potential disputes down the line, fostering a positive landlord-tenant relationship. Incorrect approaches analysis. Pressuring the tenant to sign the lease immediately without adequate review time is ethically unsound and potentially breaches the Residential Tenancies Act 2010, NSW. This approach prioritizes expediency over the tenant's right to understand the legally binding document they are entering into. It creates an environment where the tenant may feel coerced, leading to a lack of genuine consent and potential future challenges to the lease's validity or specific clauses. Suggesting the tenant can figure out the details later, once they move in, demonstrates a disregard for the importance of a clear and understood lease agreement from the outset. The lease is a critical document outlining significant obligations for both parties. Omitting or downplaying the review process undermines the legal framework designed to protect both landlord and tenant, potentially leading to disputes over rent, repairs, or termination clauses that could have been clarified during the initial review. Providing only a verbal summary of the key terms without a written copy of the lease agreement is insufficient and a significant regulatory failure. The Residential Tenancies Act 2010, NSW, requires a written agreement. Relying solely on verbal communication leaves room for misinterpretation, forgotten details, and disputes about what was actually agreed upon. It fails to provide the tenant with a tangible record of their rights and responsibilities, which is a fundamental requirement for a fair tenancy. Professional reasoning. Professionals should adopt a client-centric approach that prioritizes legal compliance and ethical conduct. This involves a systematic process of 1. Identifying legal obligations under the relevant legislation, Residential Tenancies Act 2010 NSW. 2. Assessing the potential risks of noncompliance or unethical behavior. 3. Communicating clearly and transparently with all parties involved. 4. Providing adequate time and resources for parties to understand their commitments. 5. Documenting all interactions and agreements thoroughly. In this context, the agent's primary duty is to facilitate a legally sound and ethically managed tenancy, which necessitates ensuring the tenant's informed consent to the lease agreement. Question 5. The risk matrix shows a client in New South Wales, NSW, is seeking urgent access to funds for a property purchase, and the most readily available financing option involves a higher interest rate than initially discussed. As their real estate agent, what is the most appropriate course of action to ensure you are acting ethically and in compliance with NSW regulations? Option A. Inform the client that their instruction to secure funds quickly means you will proceed without further discussion on the interest rate, as their preference is paramount. Option B. Proceed with the loan application as requested by the client, focusing on the speed of fund availability, and assume the client understands the financial implications of the higher interest rate. Option C. Downplay the significance of the higher interest rate, emphasizing that the funds will be available quickly, which is the client's primary concern. Option D. Clearly explain the long-term financial implications of the higher interest rate, including potential increased repayment amounts and overall cost of the loan, and strongly advise the client to seek independent financial advice before proceeding. The correct answer is D. Clearly explain the long-term financial implications of the higher interest rate, including potential increased repayment amounts and overall cost of the loan, and strongly advise the client to seek independent financial advice before proceeding. Explanation. This scenario presents a professional challenge due to the inherent conflict between a client's immediate financial needs and the agent's duty to ensure the client understands the full implications of their financing decisions, particularly when those decisions might lead to future financial distress. The agent must navigate this delicate balance while adhering to their fiduciary duties and the regulatory requirements of New South Wales, NSW. Careful judgment is required to avoid misrepresentation or undue influence. The best professional approach involves clearly and comprehensively explaining the implications of the proposed loan structure to the client, including the potential for increased interest payments and the impact on their overall financial position before proceeding. This includes advising the client to seek independent financial advice. This approach is correct because it aligns with the agent's duty of care and disclosure under NSW property law and the principles of ethical conduct expected of real estate professionals. Specifically, agents have a responsibility to act in the best interests of their clients and to provide them with sufficient information to make informed decisions. Recommending independent financial advice is a crucial step in fulfilling this duty, ensuring the client is not solely reliant on the agent's potentially biased perspective and is fully aware of the long-term consequences of their financing choices. An incorrect approach involves proceeding with the loan application without ensuring the client fully comprehends the long-term financial implications of the higher interest rate, simply because the client expresses a desire for immediate funds. This fails to meet the duty of care and disclosure obligations, potentially exposing the client to future financial hardship and the agent to regulatory sanctions for misleading conduct. Another incorrect approach is to downplay the significance of the higher interest rate, focusing only on the immediate availability of funds. This constitutes a misrepresentation of the financial product and breaches the agent's ethical obligation to provide accurate and complete information. It prioritizes a quick sale over the client's long-term financial well-being. A further incorrect approach is to suggest that the client's stated preference for immediate funds overrides the need for a thorough understanding of the loan terms. While client instructions are important, they do not absolve the agent of their responsibility to ensure the client is making an informed decision, especially when significant financial commitments are involved. This approach neglects the agent's fiduciary duty to protect the client's interests. Professionals should employ a decision-making framework that prioritizes client understanding and informed consent. This involves a proactive approach to disclosure, actively seeking to clarify complex financial terms, and consistently recommending independent professional advice when the client's financial situation or the proposed transaction warrants it. The agent's role is to facilitate a transaction that is in the client's best interests, not merely to fulfill a client's immediate request without due diligence. Question 6. Market research demonstrates that a family home in a well-established Sydney suburb with numerous recent sales of comparable properties is being valued for a potential sale. The agent is considering which valuation method would best reflect the property's current market worth. Option A, income approach. Option B, comparative market analysis. Option C, a combination of the income and cost approaches. Option D, cost approach. Correct answer is B, comparative market analysis. Explanation. This scenario presents a professional challenge because a licensed real estate agent in New South Wales, NSW, must select the most appropriate valuation method for a unique property, balancing the client's needs with regulatory compliance and ethical obligations. The agent must demonstrate a thorough understanding of the different valuation approaches and their applicability to specific property types, ensuring the valuation is both accurate and defensible under the Property and Stock Agents Act 2002, NSW, and relevant industry codes of conduct. The most appropriate approach in this scenario is the comparative market analysis. This method is best suited for residential properties, especially those with recent sales of similar homes in the immediate vicinity. It involves comparing the subject property to recently sold similar properties, comparables, in the same or a very similar neighborhood, adjusting for differences in features, condition, and location. This approach is favored because it directly reflects current market conditions and buyer behavior, providing a realistic estimate of market value. Under NSW regulations, agents are expected to provide valuations that are based on sound market principles and are reflective of current market realities. The comparative market analysis aligns with this expectation by grounding the valuation in observable market transactions. Using the income approach would be inappropriate and potentially misleading. This method is primarily used for investment properties where the value is derived from the income the property generates. Applying it to a family home without an income-generating component would not accurately reflect its market value and could lead to a misrepresentation of its worth to the client. This failure to select an appropriate method constitutes a breach of the duty of care owed to the client and potentially misleading conduct under NSW consumer protection laws. Similarly, employing the cost approach would be unsuitable for this residential property. This method estimates value by calculating the cost to replace or reproduce the property, minus depreciation. It is typically used for unique or new construction where comparable sales are scarce, or for insurance purposes. For an established family home, this approach often fails to capture the nuances of market demand, location desirability, and the subjective value buyers place on such properties, leading to an inaccurate valuation. This would also be considered a failure to exercise due diligence and professional competence, potentially violating the agent's obligations under the Property and Stock Agents Act 2002, NSW. Professionals should approach valuation by first understanding the property type and its primary purpose, e.g., owner-occupied residential, investment, commercial. They should then consider the availability of data relevant to each valuation method. For residential properties, the comparative market analysis is generally the starting point due to its direct reflection of market activity. If the property has unique characteristics or lacks sufficient comparable sales, then other methods might be considered as supplementary or primary, but always with a clear justification for their use and an understanding of their limitations. Ethical practice dictates transparency with the client about the chosen method and its rationale. Question: market research demonstrates that a family home in a well-established Sydney suburb, with numerous recent sales of comparable properties, is being valued for a potential sale. The agent is considering which valuation method would best reflect the property's current market worth. Options: A. Comparative market analysis. B. Income approach. C. Cost approach. D. A combination of the income and cost approaches. Question 7. Risk assessment procedures indicate that a vendor in Sydney, New South Wales, is eager for a rapid sale of their property and instructs their real estate agent to omit any mention of significant past structural repairs from the contract for sale, stating that the repairs have made the issues a non-concern. The agent is aware that the property experienced substantial foundation issues 5 years ago, which were subsequently repaired at considerable expense. What is the most appropriate course of action for the real estate agent in New South Wales? Option A. Advise the vendor that the property's history of significant structural issues, even if repaired, is a material fact that must be disclosed to prospective buyers under New South Wales law. Option B. Agree to the vendor's request to not disclose the structural issues, prioritizing the vendor's instruction to achieve a quick sale. Option C. Suggest to the vendor that the structural issue can be omitted from the contract for sale, but mentioned verbally during property inspections. Option D. Inform the vendor that since the repairs have been completed, the past structural issues are no longer relevant and do not need to be disclosed. Correct answer is A. Advise the vendor that the property's history of significant structural issues, even if repaired, is a material fact that must be disclosed to prospective buyers under New South Wales law. Explanation: scenario analysis. This scenario presents a professional challenge due to the potential conflict between a vendor's instructions and the agent's duty to disclose material facts. Agents in New South Wales have a statutory obligation to disclose certain information to prospective buyers, even if it might deter a sale. Failing to do so can lead to significant legal and ethical repercussions. The agent must navigate the vendor's desire for a quick sale against their own legal and ethical responsibilities. Correct approach analysis. The best professional practice involves advising the vendor that the property's known history of significant structural issues, even if repaired, constitutes a material fact that must be disclosed to prospective buyers under the Property and Stock Agents Act 2002, NSW, and its associated regulations. The agent should explain that withholding this information could mislead buyers and result in legal action, including claims for damages or rescission of the contract. The agent's duty is to act honestly and in accordance with the law, which prioritizes transparency in real estate transactions. This approach upholds the agent's fiduciary duties to both the vendor to act in their best interest within legal bounds and the public to ensure fair and informed transactions. Incorrect approaches analysis. Advising the vendor that the repairs make the past issues irrelevant and therefore not disclosable fails to acknowledge the ongoing obligation to disclose past material facts, regardless of subsequent repairs. The Property and Stock Agents Act 2002, NSW, requires disclosure of facts that a reasonable buyer would consider important in deciding whether to buy the property or how much to offer. The history of significant structural problems, even if repaired, is a fact that a reasonable buyer would want to know. Suggesting that the agent can omit the structural issue from the contract for sale, but mention it verbally during inspections, is a serious breach of disclosure obligations. Verbal disclosures are often difficult to prove and do not provide the same level of certainty or protection as written disclosure within the contract. This approach circumvents the spirit and letter of the law, which mandates clear and documented disclosure of material facts. Agreeing to the vendor's request to not disclose the structural issues, citing the vendor's instruction to achieve a quick sale, prioritizes the vendor's immediate financial interest over legal and ethical obligations. This abdication of responsibility can expose the agent to disciplinary action by NSW fair trading, civil liability, and damage to their professional reputation. The agent's primary duty is to act lawfully and ethically, not solely to fulfill a vendor's potentially unlawful or unethical requests. Professional reasoning. Professionals in New South Wales real estate must adopt a decision-making process that prioritizes legal compliance and ethical conduct. When faced with a conflict between client instructions and statutory obligations, the agent must first identify the relevant legislation. In this case, the Property and Stock Agents Act 2002, NSW, and associated regulations concerning disclosure. They should then assess whether the client's instruction aligns with these legal requirements. If there is a discrepancy, the agent's professional duty is to inform the client of their legal obligations and advise them on the correct course of action. This involves clearly explaining the potential consequences of noncompliance and recommending a path that adheres to both the law and ethical standards. The agent should document all advice given and received. If the client insists on an unlawful or unethical course of action, the agent may need to consider withdrawing from the agency agreement. Question 8. Quality control measures reveal that a married couple in New South Wales, NSW, is purchasing a residential property together as co-owners. They have expressed a desire for the property to pass to their children upon the death of one of them, but they also want to ensure that if one spouse predeceases the other, the surviving spouse can continue to reside in the property without immediate disruption, which approach best addresses their stated intentions and complies with NSW property law. Option A. Advise the couple to hold the property as joint tenants, as this automatically provides for the surviving spouse to inherit the entire property, and then have them separately consider their wills for the ultimate distribution to their children. Option B. Advise the couple to enter into a simple informal agreement outlining their wishes for the property, without formally specifying the type of co-ownership, as their marital status implies a clear understanding. Option C. Advise the couple to hold the property as tenants in common, with each spouse owning an undivided 50% share, and ensure their wills clearly direct their respective shares to their children, while also establishing a life interest or similar arrangement in their wills to allow the surviving spouse to reside in the property. Option D. Advise the couple to hold the property as tenants in common, with each spouse owning an undivided 50% share, and rely on the presumption that their children will inherit the property through intestacy laws if no wills are made. The correct answer is C. Advise the couple to hold the property as tenants in common, with each spouse owning an undivided 50% share, and ensure their wills clearly direct their respective shares to their children, while also establishing a life interest or similar arrangement in their wills to allow the surviving spouse to reside in the property. Explanation. This scenario presents a professional challenge due to the potential for misinterpreting or misapplying the nuances of property ownership structures in New South Wales, NSW, which can lead to significant legal and financial consequences for clients. Careful judgment is required to ensure advice aligns with the client's true intentions and the relevant NSW property law. The best professional approach involves thoroughly understanding the client's stated intentions and their relationship dynamics to advise on the most appropriate form of co-ownership under NSW law. This means explaining the implications of joint tenancy, right of survivorship, and tenancy in common, individual shares that can be bequeathed, and guiding them towards the structure that best reflects their wishes for asset distribution and future control. This approach is correct because it prioritizes client instruction and ensures compliance with the Conveyancing Act 1919, NSW, and common law principles governing co-ownership, preventing unintended outcomes like automatic transfer of property upon death in a way that contradicts a client's wishes. An incorrect approach would be to automatically assume joint tenancy for any co-owned property, especially when clients are a couple, without explicit discussion. This fails to acknowledge that tenancy in common is a valid and often preferred alternative, particularly if clients wish to retain individual control over their respective shares, or ensure their property passes to specific beneficiaries other than their co-owner. This oversight can lead to a breach of fiduciary duty and contravene the client's actual intentions, potentially causing disputes and legal challenges. Another incorrect approach is to solely focus on the practicalities of managing the property without adequately explaining the legal distinctions between joint tenancy and tenancy in common. While practical considerations are important, the fundamental legal structure of ownership dictates how the property will be treated upon the death of a co-owner or in the event of a sale. Failing to clearly articulate these legal differences, as governed by NSW legislation and case law, leaves clients uninformed and vulnerable to making decisions based on incomplete understanding. A further incorrect approach would be to advise based on general property law principles without specific reference to NSW legislation. While some principles are universal, the specifics of co-ownership, including the presumption of joint tenancy at common law and the ability to sever joint tenancies, are codified and interpreted within the NSW legal framework. Relying on generic knowledge without consulting the Conveyancing Act 1919, NSW, or relevant NSW case law risks providing advice that is not legally sound within the specific jurisdiction. The professional decision-making process for similar situations should involve a structured client consultation that begins with understanding their objectives for acquiring and holding the property. This includes exploring their intentions regarding inheritance, potential future sale, and their relationship with the co-owner. Subsequently, the professional must clearly explain the legal characteristics and implications of each available co-ownership structure under NSW law, such as fee simple, leasehold, joint tenancy, and tenancy in common, highlighting the critical differences, particularly the right of survivorship in joint tenancy versus the individual share ownership in tenancy in common. The professional should then recommend the structure that best aligns with the client's stated intentions and legal requirements, ensuring all advice is documented and confirmed by the clients. Question 9. Compliance review shows a real estate agent in New South Wales is advising a client on the potential for subdividing a residential property. The agent has a general understanding of the area's market, but has not yet consulted the specific planning instruments governing land use for that locality. Which approach best ensures the agent provides accurate and compliant advice regarding the property subdivision potential under New South Wales law? Option A. Proactively research the relevant local environmental plan (LEP) and development control plan (DCP) for the specific local government area (LGA) where the property is situated. Option B. Rely on informal advice from a neighbor who has previously undertaken a similar project or on marketing materials from a previous sale of the property. Option C. Suggests that subdivision is likely achievable as long as the proposed development is aesthetically pleasing and aligns with the general character of the neighborhood. Option D. Advise the client based on the property's current residential use and general market trends for similar properties in the region. The correct answer is A. Proactively research the relevant local environmental plan (LEP) and development control plan (DCP) for the specific local government area (LGA) where the property is situated. Explanation. Scenario analysis. This scenario presents a professional challenge because it requires a real estate agent in New South Wales (NSW) to navigate the complexities of local council zoning laws and development controls when advising a client on property potential. Misinterpreting or misrepresenting these regulations can lead to significant financial loss for the client, reputational damage for the agent, and potential legal repercussions. The agent must demonstrate a thorough understanding of the NSW planning system and the specific local environmental plan, LEP, and development control plan, DCP, applicable to the property. Correct approach analysis. The best professional practice involves the agent proactively researching the relevant local environmental plan, LEP, and development control plan, DCP, for the specific local government area, LGA, where the property is situated. This approach is correct because NSW's planning system is governed by these documents, which detail permissible land uses, development standards, and any specific restrictions or requirements for a particular parcel of land. By consulting these official documents, the agent can provide accurate, legally sound advice regarding the property's development potential, ensuring compliance with NSW planning legislation. This demonstrates due diligence and upholds the agent's duty of care to the client. Incorrect approach is analysis. Advising the client based solely on the property's current use and general market trends, without consulting the specific LEP and DCP, is professionally unacceptable. This approach fails to acknowledge the legally binding nature of zoning and land use regulations in NSW. The current use or market perception does not guarantee future development rights or permissibility under the planning controls. Relying on informal advice from a neighbor or a previous agent's marketing materials is also professionally unsound. While these sources might offer some anecdotal information, they do not constitute official planning advice and can be outdated, inaccurate, or specific to different circumstances. This approach bypasses the formal regulatory framework and exposes the client to significant risk. Suggesting that any development is possible as long as it is reasonable, or appeals to the council, without referencing the specific planning controls, is a failure to provide informed advice. The concept of reasonableness in development is defined by the LEP and DCP, not by subjective interpretation. Approvals are granted based on compliance with established planning instruments, not on informal appeals to council members. Professional reasoning. Professionals in NSW real estate must adopt a systematic approach to advising clients on land use and development. This involves 1. Identifying the relevant local government area, LGA, and the specific property. 2. Accessing and thoroughly reviewing the applicable local environmental plan, LEP, and development control plan, DCP, for that LGA. 3. Interpreting the zoning designation and any specific development standards, permissible uses, and restrictions outlined in the LEP and DCP. 4. Cross-referencing this information with any relevant state environmental planning policies, SEP, that may apply. 5. Providing advice to the client that is grounded in these official planning documents, clearly outlining what is permissible, what requires development consent, and any potential limitations. 6. Recommending that the client seek independent professional advice from a town planner or legal professional for complex development proposals. Question 10. Analysis of a property listing in Sydney, New South Wales, reveals that a recently constructed shed on the property appears to extend approximately 0.5 meters over the boundary line of the neighboring property, as indicated by existing fencing. The vendor states they built the shed themselves 5 years ago and believes the fence is the correct boundary. As the licensed real estate agent, you have a duty to accurately represent the property. If the shed is indeed encroaching, this constitutes a significant issue affecting the property rights and ownership of both properties. You are tasked with determining the most appropriate course of action to ensure compliance with New South Wales property law and ethical standards. Option A. Advise the vendor that a professional survey is required to definitively establish the property boundaries, and then disclose the survey findings to potential purchasers, recommending a price adjustment if an encroachment is confirmed. Option B. Inform potential purchasers that there might be a slight boundary issue with the shed and suggest they obtain their own survey to clarify the situation. Option C. Assume the fence is the correct boundary and market the property based on the current physical occupation, without obtaining a survey or discussing the potential encroachment with the vendor. Option D. Rely on the vendor's statement that the fence represents the correct boundary and proceed with marketing the property without further investigation into the shed's placement. Correct answer is A. Advise the vendor that a professional survey is required to definitively establish the property boundaries, and then disclose the survey findings to potential purchasers, recommending a price adjustment if an encroachment is confirmed. Explanation. This scenario presents a professional challenge due to the inherent conflict between a licensee's duty to their client and the legal requirements surrounding property transactions, specifically concerning the accurate disclosure of property boundaries and potential encroachments. The licensee must navigate the complexities of property rights and ownership in New South Wales, ensuring all parties are fully informed and that the transaction adheres to the Conveyancing Act 1919, NSW, and relevant property law principles. The ethical imperative is to act with honesty, integrity, and in the best interests of the client while upholding legal obligations. The best professional approach involves a thorough investigation of the property's boundaries and any potential encroachments, followed by full disclosure to the vendor and potential purchasers. This includes obtaining a survey report if necessary to definitively establish boundary lines. This approach is correct because it directly addresses the legal requirement for accurate representation of property and aligns with the ethical duty of disclosure. Under the Property and Stock Agents Act 2002, NSW, licensees have a duty to act honestly and in the best interests of their clients, which includes providing accurate information about the property being sold. Furthermore, the principle of caveat emptor, buyer beware, is significantly mitigated by statutory disclosure obligations, meaning the vendor, and by extension their agent, must proactively reveal material facts. An incorrect approach would be to rely solely on the vendor's verbal assurance without independent verification. This is professionally unacceptable as it breaches the duty of care and disclosure. The licensee is not absolved of their responsibility by the vendor's statements. They must exercise due diligence. Relying on outdated plans without confirming current boundary lines is also a failure, as physical occupation and subsequent boundary shifts can occur. Finally, advising the purchaser to obtain their own survey without the vendor first disclosing the potential issue and offering to rectify it or adjust the price is a dereliction of the vendor's agent's duty to present the property accurately from the outset. Professionals should adopt a decision-making process that prioritizes legal compliance and ethical conduct. This involves 1. Identifying potential issues, e.g., apparent boundary discrepancies. 2. Consulting relevant legal frameworks and professional standards, e.g., Property and Stock Agents Act 2002, NSW, Conveyancing Act 1919, NSW. 3. Conducting necessary investigations, e.g., obtaining surveys, reviewing title documents. 4. Disclosing all material facts to all parties involved. 5. Seeking legal advice if the situation is complex or uncertain. Question 11. The review process indicates that a property manager in New South Wales, NSW, has identified a need for urgent repairs to a rental property they manage. The property manager's sibling owns a reputable local repair company, and the property manager is considering engaging this company to perform the work, believing they can ensure a prompt and quality service. What is the most appropriate course of action for the property manager to take in this situation? Option A. Proceed with engaging the siblings' repair company, as they are known for prompt and quality service, and inform the landlord only after the repairs are completed and paid for. Option B. Engage the siblings' repair company without informing the landlord, as the property manager is confident in their siblings' ability to provide good service and avoid any overcharging. Option C. Immediately disclose the relationship with the repair company to the landlord and seek their explicit written consent before proceeding with any engagement. Option D. Engage a different, unrelated repair company to perform the work to avoid any appearance of impropriety without mentioning the siblings' company to the landlord. The correct answer is C. Immediately disclose the relationship with the repair company to the landlord and seek their explicit written consent before proceeding with any engagement. Explanation. The review process indicates a potential conflict of interest and a breach of trust in the management of a rental property in New South Wales, NSW. This scenario is professionally challenging because it requires the property manager to balance the interests of the landlord with their own personal gain, while adhering to strict legal and ethical obligations. Careful judgment is required to ensure transparency, fairness, and compliance with the Property and Stock Agents Act 2002, NSW, and its associated regulations, as well as general principles of fiduciary duty. The best professional approach involves immediately disclosing the potential conflict of interest to the landlord and seeking their informed consent before proceeding with any repairs. This approach upholds the property manager's fiduciary duty to act in the best interests of the landlord. Transparency is paramount. By disclosing the relationship with the repair company, the property manager allows the landlord to make an informed decision about whether to proceed with that specific company or seek alternative quotes. This aligns with the ethical obligations of honesty and integrity expected of licensed agents in NSW, and the regulatory requirement to avoid conflicts of interest or to manage them appropriately through disclosure and consent. An incorrect approach would be to proceed with the repairs using the company owned by the property manager's relative without any disclosure. This fails to address the inherent conflict of interest. The property manager is not acting solely in the landlord's best interest, as there is a personal financial benefit derived from the repair work. This breaches the duty of loyalty and good faith owed to the landlord, and contravenes the spirit and letter of the Property and Stock Agents Act 2002, NSW, which mandates agents to act honestly and competently, and to avoid situations where their personal interests could compromise their professional duties. Another incorrect approach would be to inform the landlord only after the repairs are completed and paid for. This is a failure of proactive disclosure. The landlord is denied the opportunity to make an informed decision at the outset, and the property manager has already acted in a way that suggests a conflict of interest was not properly managed. This lack of transparency erodes trust and can lead to disputes, potentially resulting in disciplinary action under NSW real estate regulations. Finally, an incorrect approach would be to engage a different, unrelated repair company without informing the landlord about the initial potential conflict and the existence of the relative's company. While this might seem like a way to avoid direct personal gain from the repair, it still involves a lack of full disclosure to the landlord regarding the property manager's connections and potential conflicts. The landlord has a right to know all relevant information that might influence their decisions regarding their property. Professionals should adopt a decision-making framework that prioritizes transparency, honesty, and adherence to regulatory requirements. When a potential conflict of interest arises, the first step should always be to identify it. The next step is to assess the nature and severity of the conflict. Then, the professional must consider their legal and ethical obligations, particularly regarding disclosure and the duty to act in the client's best interests. Seeking informed consent from the client is crucial. If informed consent cannot be obtained, or if the conflict is too significant to manage, the professional should consider withdrawing from the situation to avoid compromising their integrity and breaching their duties. Question 12. Performance analysis shows that a mortgage broker in New South Wales is processing a home loan application for a client who has recently experienced a significant change in their employment status, moving from a permanent role to a contract position with variable income. Considering the regulatory framework governing mortgage applications in NSW, which of the following actions best demonstrates adherence to professional obligations and the National Credit Code? Option A. The broker proceeds with the application using the client's previous permanent employment details, assuming the lender will overlook the minor change in employment status given the client's strong credit history. Option B. The broker advises the client to omit the change in employment status from the application to avoid potential complications with the lender, suggesting they can manage the repayments. Option C. The broker thoroughly investigates the nature of the new contract, including its duration, the client's projected earnings, and any potential for future permanent employment, and ensures all these details, along with the change in employment status, are clearly and accurately disclosed to the lender. Option D. The broker submits the application with only the client's current contract income, without detailing the change from permanent employment, or inquiring about the stability and duration of the contract. The correct answer is C. The broker thoroughly investigates the nature of the new contract, including its duration, the client's projected earnings, and any potential for future permanent employment, and ensures all these details, along with the change in employment status, are clearly and accurately disclosed to the lender. Explanation. Scenario analysis. This scenario presents a professional challenge for a mortgage broker in New South Wales, NSW, due to the critical importance of accurate and complete disclosure during the mortgage application process. Failure to properly disclose material information can lead to significant legal and financial repercussions for both the borrower and the broker, including potential penalties under the National Credit Code and ASIC regulatory guidance. The broker must exercise careful judgment to ensure all relevant details are captured and communicated effectively to the lender, balancing the borrower's interests with the lender's need for accurate risk assessment. Correct approach analysis. The best professional practice involves the mortgage broker meticulously reviewing the borrower's financial situation, including all sources of income, existing debts, and any significant life changes that could impact their ability to repay the loan. This includes actively questioning the borrower about any potential changes or unusual circumstances, such as upcoming job changes, significant planned expenditures, or any other factors that might be considered material by a lender. The broker should then ensure that all this information is accurately recorded and clearly communicated to the lender in the loan application. This approach aligns with the broker's duty of care and the requirements under the National Credit Code, as regulated by ASIC and NSW, to act in the best interests of the borrower and to ensure that credit is provided responsibly. It prioritizes transparency and thoroughness, which are fundamental ethical and regulatory obligations. Incorrect approaches analysis, relying solely on the borrower's self-reported information without further probing or verification, especially when there are indications of potential complexities or changes, is an unacceptable approach. This failure to conduct due diligence could result in the lender making a decision based on incomplete or misleading information, potentially breaching responsible lending obligations. Assuming that a previous loan application with the same lender for a similar amount would automatically be approved without a fresh, comprehensive review of the current financial circumstances is also professionally unsound. Each application must be assessed on its own merits based on the most up-to-date information, and past approvals do not guarantee future ones, nor do they absolve the broker of their duty to ensure current accuracy. Focusing only on securing the highest possible loan amount for the borrower without adequately assessing their genuine capacity to repay, based on a thorough understanding of their current financial position and any potential future impacts, is a direct contravention of responsible lending principles. This prioritizes commission over the borrower's financial well-being and regulatory compliance. Professional reasoning. Professionals in NSW, when navigating the mortgage application process, should adopt a systematic and diligent approach. This involves 1. Understanding the borrower's complete financial picture, including income, expenses, assets, and liabilities. 2. Actively seeking out and clarifying any information that might be considered material or could impact repayment capacity, including potential future changes. 3. Accurately documenting all gathered information and presenting it transparently to the lender. 4. Ensuring compliance with the National Credit Code and ASIC guidelines, particularly regarding responsible lending and disclosure obligations. This structured approach ensures that the broker acts ethically, legally, and in the best interests of both the borrower and the lender. Question 13. Quality control measures reveal that a real estate agent in New South Wales is advising a client on the sale of their property. The agent has observed a recent upward trend in property values in the local area over the past 18 months. Considering the cyclical nature of real estate markets in NSW, which of the following approaches best reflects professional and ethical conduct in providing advice on the optimal timing for the sale? Option A. Conduct a thorough analysis of historical market data for the specific NSW region, including past cycles, current economic indicators, interest rate trends, and projected supply and demand, to present a balanced outlook on potential future market movements, and advise on a sales strategy that considers both short-term gains and long-term market dynamics. Option B. Base the advice primarily on conversations with other local agents and anecdotal evidence of recent sales, suggesting a sale is opportune based on general market sentiment rather than specific data analysis. Option C. Recommend delaying the sale significantly, focusing exclusively on negative economic forecasts and potential interest rate hikes that could lead to a market downturn, without adequately considering any potential for continued growth or market stability. Option D. Advise the client to list the property immediately, emphasizing the strong recent price growth and projecting that this upward trend will continue indefinitely, leading to maximum returns in the short term. The correct answer is A. Conduct a thorough analysis of historical market data for the specific NSW region, including past cycles, current economic indicators, interest rate trends, and projected supply and demand, to present a balanced outlook on potential future market movements, and advise on a sales strategy that considers both short-term gains and long-term market dynamics. Explanation: this scenario presents a professional challenge because it requires a real estate agent in New South Wales to interpret market trends and advise a client without succumbing to personal bias or misrepresenting information. The agent must balance the client's immediate financial goals with the broader, long-term implications of market cycles, adhering to their duty of care and disclosure obligations under NSW real estate law. The challenge lies in providing objective, evidence-based advice that is both accurate and actionable, considering the inherent volatility of real estate markets. The best approach involves a comprehensive analysis of historical and current market data specific to the relevant NSW region, considering factors like interest rates, economic indicators, population growth, and supply-demand dynamics. This approach aligns with the agent's fiduciary duty to act in the client's best interest and the disclosure requirements under the Property and Stock Agents Act 2002, NSW, and its associated regulations. By presenting a balanced view of potential future trends, including both optimistic and pessimistic scenarios, the agent fulfills their obligation to provide informed advice, allowing the client to make a well-considered decision. This method prioritizes transparency and client education, fostering trust and ensuring compliance with professional standards. An approach that focuses solely on recent positive price growth and extrapolates this trend indefinitely without considering potential downturns or market saturation is professionally unacceptable. This failure to acknowledge the cyclical nature of real estate markets can lead to misrepresentation and a breach of the agent's duty to provide accurate advice. It ignores the potential for significant financial loss for the client if the market corrects. Similarly, an approach that emphasizes only negative market indicators and predicts a severe downturn without acknowledging any potential for recovery or growth is also problematic. While caution is important, an overly pessimistic outlook can unduly influence the client's decision-making, potentially causing them to miss out on a favorable investment opportunity. This selective presentation of data can be seen as a failure to provide a complete and balanced market assessment. Furthermore, an approach that relies on anecdotal evidence or speculative rumors rather than objective data is unprofessional and unethical. Real estate advice must be grounded in factual analysis and market research, not hearsay. Such an approach undermines the credibility of the agent and exposes the client to significant risk due to decisions based on unreliable information. Professionals should adopt a decision-making framework that prioritizes objective data analysis, thorough market research specific to the NSW context, and transparent communication with the client. This involves understanding the inherent cyclical nature of real estate, identifying key drivers of market change, and presenting a range of potential future scenarios with their associated risks and opportunities. Agents must always act with integrity, ensuring their advice is in the client's best interest and complies with all relevant NSW legislation and ethical guidelines. Question 14. Investigation of a property sale in Sydney, New South Wales, reveals that a real estate agent, acting on behalf of a vendor, has been instructed to advertise the property exclusively in niche publications and online forums frequented by a specific ethnic community, with the stated aim of attracting buyers from that background. The agent is also considering using marketing language that subtly highlights the property's suitability for families with young children, potentially discouraging single individuals or couples without children. What is the most appropriate course of action for the agent to ensure compliance with New South Wales fair housing laws and anti-discrimination regulations? Option A. Focus marketing efforts on highlighting the property's suitability for families with young children, as this is a common and acceptable way to attract a specific buyer demographic. Option B. Develop a broad marketing campaign utilizing a diverse range of mainstream and specialized channels, ensuring all marketing materials are inclusive and do not make assumptions or exclusions based on protected attributes, while advising the vendor that discriminatory marketing practices are unlawful. Option C. Comply with the vendor's instructions to advertise exclusively in niche publications and online forums frequented by the specific ethnic community, as this is a direct request from the client. Option D. Advise the vendor that while direct discrimination is illegal, targeting specific communities through specialized advertising is a legitimate business practice to maximize interest. The correct answer is B. Develop a broad marketing campaign utilizing a diverse range of mainstream and specialized channels, ensuring all marketing materials are inclusive and do not make assumptions or exclusions based on protected attributes, while advising the vendor that discriminatory marketing practices are unlawful. Explanation: this scenario presents a professional challenge because it requires navigating the delicate balance between legitimate business interests and the stringent anti-discrimination provisions of New South Wales, NSW, fair housing laws. A real estate agent must exercise careful judgment to avoid even the appearance of discriminatory practices, which can lead to significant legal and reputational consequences. The agent's duty is to market properties fairly and equitably to all potential buyers, irrespective of their personal characteristics. The best professional approach involves a comprehensive and objective marketing strategy that targets the broadest possible audience, without making assumptions or exclusions based on protected attributes. This includes utilizing a diverse range of advertising channels and ensuring that marketing materials are inclusive and do not inadvertently discourage specific groups from inquiring. The agent must be prepared to demonstrate that their marketing efforts were designed to reach all segments of the potential buyer pool, thereby complying with the spirit and letter of the Anti-Discrimination Act 1977, NSW, and the Residential Tenancies Act 2010, NSW, which prohibit discrimination in the sale and rental of property. An approach that focuses solely on advertising in publications or online platforms perceived to be frequented by a specific demographic, while excluding others, is professionally unacceptable. This can be construed as an attempt to steer potential buyers away from a property based on assumptions about their background, directly contravening the prohibition against discrimination on the grounds of race, sex, age, disability, and other protected attributes under NSW law. Similarly, tailoring marketing messages to appeal exclusively to a particular group, even if not explicitly discriminatory, can create an environment where others feel unwelcome or excluded, leading to indirect discrimination. Furthermore, responding to vendor instructions that suggest discriminatory marketing practices without challenging them or advising on legal compliance is a failure to uphold professional standards and legal obligations. Professionals should employ a decision-making framework that prioritizes legal compliance and ethical conduct. This involves understanding the specific anti-discrimination legislation in NSW, critically evaluating vendor instructions to ensure they align with legal requirements, and proactively developing marketing strategies that are inclusive and accessible to all potential buyers. When in doubt, seeking clarification from legal counsel or professional bodies is a crucial step in ensuring responsible practice. The agent's primary responsibility is to act in the best interests of the vendor, while strictly adhering to all applicable laws and ethical guidelines. Question 15. Comparative studies suggest that in New South Wales, when a real estate agent becomes aware of significant structural issues with a property they are marketing, what is the most compliant and ethically sound course of action regarding disclosure to potential buyers? Option A. Advise prospective buyers that the structural issues are minor and unlikely to affect the property's value significantly. Option B. Suggest that prospective buyers arrange their own independent building inspection before discussing any known structural issues. Option C. Wait until a formal offer is submitted by a buyer before disclosing the structural issues. Option D. Immediately disclose the known structural issues to all prospective buyers, irrespective of whether an offer has been made. The correct answer is D. Immediately disclose the known structural issues to all prospective buyers, irrespective of whether an offer has been made. Explanation: this scenario is professionally challenging because it requires the agent to balance the seller's desire for a quick sale with their fiduciary duty to disclose material facts that could affect a buyer's decision. The agent must navigate potential conflicts of interest and ensure compliance with the Property and Stock Agents Act 2002, NSW, and its associated regulations, as well as common law duties of disclosure. Careful judgment is required to avoid misleading potential buyers or breaching their trust. The best professional approach involves the agent proactively informing the prospective buyer about the known structural issues, even before a formal offer is made. This aligns with the agent's statutory obligation under the Property and Stock Agents Act 2002, NSW, to act honestly and in good faith, and to disclose all material facts that they know or ought reasonably to know that might affect the value of the property or the buyer's decision to purchase. Ethically, this demonstrates transparency and upholds the principle of informed consent, which is fundamental to fair dealings in real estate transactions. By disclosing early, the agent allows the buyer to make an informed decision and avoids potential future disputes or claims of misrepresentation. An incorrect approach would be to wait for a formal offer before disclosing the structural issues. This could be seen as an attempt to secure a sale without providing the buyer with all necessary information, potentially breaching the agent's duty of disclosure. It might also lead to the buyer feeling misled if they discover the issues after making an offer or even after purchase, potentially resulting in legal action for misrepresentation or breach of duty. Another incorrect approach would be to downplay the severity of the structural issues to the prospective buyer. While the agent may be trying to reassure the seller, this action directly violates the duty to disclose material facts accurately and without embellishment. It is the agent's responsibility to present facts objectively, allowing the buyer to assess the implications themselves. Misrepresenting the condition of the property is a serious ethical and regulatory breach. Finally, an incorrect approach would be to suggest that the buyer obtain their own independent advice without the agent first disclosing the known issues. While encouraging independent advice is good practice, it should not be a substitute for the agent's own primary duty to disclose material facts that they are aware of. The agent cannot abdicate their responsibility to inform by simply deferring the buyer to others without first fulfilling their own disclosure obligations. Professionals should adopt a decision-making process that prioritizes transparency and compliance. This involves identifying all known material facts about a property, understanding their potential impact on value and buyer interest, and disclosing these facts promptly and clearly to all prospective buyers, regardless of the stage of the transaction. When in doubt about whether a fact is material, it is always safer to disclose. This proactive approach builds trust, mitigates risk, and upholds the integrity of the real estate profession in New South Wales. Question 16. The investigation demonstrates that a real estate agent in New South Wales is discussing commission structures with a potential vendor. What approach best upholds professional standards and regulatory compliance in New South Wales? Option A. Proposing a commission structure that is heavily weighted towards a bonus payment upon achieving a sale price significantly above the initial appraisal, without detailed explanation of how this might influence negotiation strategy. Option B. Waiting until an offer is received and accepted before finalizing the commission percentage with the vendor to ensure it reflects the effort involved in securing the sale. Option C. Presenting multiple commission structure options in writing to the vendor, clearly explaining the implications of each, and ensuring the vendor understands and agrees to the chosen arrangement before signing the agency agreement. Option D. Verbally agreeing to a commission percentage with the vendor, with the understanding that the final written agreement will reflect this verbal understanding. The correct answer is C. Presenting multiple commission structure options in writing to the vendor, clearly explaining the implications of each, and ensuring the vendor understands and agrees to the chosen arrangement before signing the agency agreement. Explanation. This scenario presents a professional challenge because it requires a real estate agent in New South Wales to navigate the ethical and legal complexities of commission structures, while ensuring transparency and fairness to both the vendor and the agency. The agent must balance the desire to secure a sale with the obligation to act in the vendor's best interests and adhere to the Property and Stock Agents Act 2002, NSW, and its associated regulations, particularly concerning disclosure and fair dealing. The best professional practice involves clearly outlining all potential commission structures and fee arrangements in writing to the vendor at the outset of the agency agreement. This approach ensures full transparency, allowing the vendor to make an informed decision based on their understanding of how the agent will be remunerated. It aligns with the principles of good faith and honest dealing mandated by NSW legislation, which requires agents to disclose all material facts and avoid misleading or deceptive conduct. By presenting options and explaining the implications of each, the agent upholds their fiduciary duty to the vendor and builds trust. An approach that involves verbally agreeing to a commission structure without subsequent written confirmation is professionally unacceptable. This failure to document the agreement creates ambiguity and opens the door to disputes, potentially violating the requirement for written agency agreements under NSW law. It also lacks the transparency necessary for the vendor to fully understand their obligations. Another professionally unacceptable approach is to present a commission structure that is contingent on achieving a sale price significantly above market value, without clearly explaining the rationale or potential impact on the negotiation process. This could be seen as incentivizing the agent to push for an unrealistic price, potentially to the detriment of the vendor's ability to achieve a timely sale, and may breach the duty to act honestly and in the best interests of the vendor. Finally, an approach where the commission structure is only disclosed late in the sales process, after the vendor has already committed to the agent, is also professionally unsound. This lack of upfront disclosure prevents the vendor from making a fully informed decision about engaging the agent and their chosen fee arrangement, potentially constituting misleading or deceptive conduct under NSW consumer protection laws. Professionals should adopt a decision-making framework that prioritizes transparency, clear communication, and adherence to regulatory requirements. This involves documenting all significant agreements in writing, explaining all fee structures and their implications comprehensively, and ensuring the client has a full understanding before any commitment is made. The agent's primary duty is to the client, and all arrangements must reflect this principle. Question 17. In New South Wales, when advising a client on the suitability of a real estate investment trust REIT as an investment, what is the most appropriate professional approach to ensure compliance with regulatory obligations and client best interests? Option A. Conduct a detailed assessment of the client's financial situation, investment objectives, and risk tolerance. Provide the REIT product disclosure statement, PDS, and explain its contents, and recommend the REIT only if it aligns with the documented client profile. Option B. Focus the recommendation on the potential tax advantages of investing in the REIT, as this is often a primary driver for investors in such products. Option C. Recommend the REIT based on its strong historical performance over the past 5 years, assuming it will continue to deliver similar returns. Option D. Advise the client that the REIT is a secure investment, highlighting its potential to outperform traditional savings accounts without detailing specific market risks. The correct answer is A. Conduct a detailed assessment of the client's financial situation, investment objectives, and risk tolerance. Provide the REIT product disclosure statement, PDS, and explain its contents, and recommend the REIT only if it aligns with the documented client profile. Explanation. Scenario analysis. This scenario presents a professional challenge for a financial advisor in New South Wales, NSW. When advising a client on investing in a real estate investment trust REIT, the challenge lies in ensuring the advice provided is not only financially suitable, but also compliant with the Corporations Act 2001, CTH, and ASIC Regulatory Guide 240, RG 240, concerning disclosure and responsible selling practices, particularly when dealing with potentially complex investment products like REIT. The advisor must navigate the client's risk tolerance, financial situation, and understanding of the investment's nature, while also adhering to disclosure obligations regarding fees, risks, and the REIT underlying assets and structure. Misinterpreting or failing to adequately disclose these aspects can lead to significant regulatory breaches and client detriment. Correct approach analysis. The best professional practice involves a thorough, documented assessment of the client's financial situation, investment objectives, and risk tolerance, followed by a clear and comprehensive explanation of the REIT-specific characteristics, risks, and fees. This approach necessitates providing the client with the REIT product disclosure statement, PDS, and ensuring they understand its contents, particularly concerning the underlying property portfolio, liquidity management structure, and any associated gearing. The advisor must then recommend the REIT only if it aligns with the documented client profile and provide ongoing support to address any queries. This aligns with the principles of responsible product distribution and disclosure under ASIC RG 240, which mandates that financial product advice must be in the client's best interests and that adequate disclosure of risks and fees is provided. Incorrect approaches analysis. Recommending the REIT solely based on its historical performance without a detailed client needs assessment or disclosure of the PDS fails to meet the best interest duty under the Corporations Act 2001, CTH, and a SIC RG 240. This approach prioritizes potential returns over client suitability and adequate risk disclosure, potentially exposing the client to undue risk, suggesting the rate as a safe haven investment without a thorough explanation of its specific risks, such as market fluctuations affecting property values, interest rate sensitivity, and potential liquidity issues, constitutes misleading or deceptive conduct. This misrepresents the investment's true nature and fails to provide the client with the necessary information to make an informed decision, violating disclosure obligations. Focusing only on the potential tax benefits of the rate, without a holistic review of the client's overall financial position and investment objectives, is an incomplete and potentially detrimental approach. It neglects other crucial factors like capital growth, income generation, and the overall risk profile of the investment in the context of the client's broader portfolio, thereby failing to act in the client's best interests. Professional reasoning. Financial advisors in NSW must adopt a client-centric approach, prioritizing thorough due diligence and transparent disclosure. This involves a structured process. First, understanding the client comprehensively through detailed fact-finding and documentation. Second, evaluating investment products against this client profile, considering all relevant risks, fees, and benefits. Third, providing clear, understandable, and complete disclosure, including the PDS. And finally, ensuring the recommendation is demonstrably in the client's best interests, with ongoing monitoring and support. This systematic process, grounded in regulatory requirements like the Corporations Act 2001, CTH, and a SIC RG 240, safeguards both the client and the advisor. Question 18. The audit findings indicate a potential oversight in the application of government-backed loan schemes within New South Wales. A loan officer has processed an application for a government-assisted mortgage based on the borrower's overall creditworthiness and income, without explicitly confirming adherence to the specific eligibility criteria and documentation requirements unique to the particular New South Wales government-backed program. What is the most appropriate professional response to address this situation and prevent future occurrences? Option A. Assume the loan is valid if the borrower meets general lending standards, as government-backed programs are typically designed to be inclusive and often align with standard credit assessment practices. Option B. Immediately review the specific legislative and policy guidelines for the New South Wales government-backed loan program in question to ensure all eligibility criteria and documentation requirements were met, and implement a mandatory checklist for all future applications under similar schemes. Option C. Proceed with the loan approval, but advise the borrower that they may need to provide additional documentation later if the program administrators request it, to avoid delaying the current transaction. Option D. Focus on the institution's internal lending policies, assuming they are sufficiently robust to cover the requirements of government-backed loans without needing to consult the specific program's external regulations. The correct answer is B. Immediately review the specific legislative and policy guidelines for the New South Wales government-backed loan program in question to ensure all eligibility criteria and documentation requirements were met, and implement a mandatory checklist for all future applications under similar schemes. Explanation. The audit findings indicate a potential misinterpretation of government-backed loan programs in New South Wales, specifically concerning the eligibility and application processes for schemes designed to assist specific borrower groups. This scenario is professionally challenging because it requires a nuanced understanding of the specific legislative frameworks governing these loans beyond general lending principles. Misapplication can lead to significant financial and reputational damage for both the lender and the borrower, and could result in regulatory penalties. Careful judgment is required to ensure compliance with the specific requirements of each government-backed initiative. The best professional practice involves a thorough review of the specific eligibility criteria and application procedures mandated by the relevant New South Wales government-backed loan schemes, such as those potentially administered or overseen by state agencies, or through federal programs with state-specific implementation guidelines. This approach prioritizes adherence to the precise legislative and policy requirements of each program, ensuring that all documentation and borrower qualifications meet the exact standards set forth. This is correct because it directly addresses the regulatory obligations and the intent of government assistance programs, which are designed with specific objectives and strict operational parameters. Ethical practice dictates full transparency and accuracy in representing and processing these loans. An approach that relies on general lending knowledge without verifying the specific nuances of New South Wales government-backed loan programs is professionally unacceptable. This fails to acknowledge that these programs often have unique eligibility requirements, documentation needs, and approval processes that differ from standard commercial loans. Such a failure constitutes a breach of regulatory compliance, as it does not adhere to the specific legislative framework governing these schemes. Another unacceptable approach is to assume that a borrower's general financial stability is sufficient for approval under a government-backed scheme, without confirming their eligibility for the specific program's intended beneficiaries, e.g., first home buyers, regional residents, or those in specific professions. This overlooks the targeted nature of these programs and can lead to misallocation of government resources and potential fraud. It also breaches the ethical duty to act with due diligence and to ensure that assistance is provided to those it is intended for. Finally, an approach that prioritizes speed of processing over meticulous verification of compliance with the specific requirements of the New South Wales government-backed loan programs is also professionally unsound. This can lead to errors in documentation or eligibility assessment, potentially invalidating the loan and exposing the institution to regulatory scrutiny and penalties. It undermines the integrity of the program and the trust placed in the institution to administer it correctly. Professionals should adopt a decision-making framework that begins with identifying the specific government-backed loan program in question within New South Wales. This should be followed by a detailed review of the relevant legislation, regulations, and program guidelines. A checklist approach, tailored to the specific program's requirements, should be used to verify all aspects of borrower eligibility and documentation. Any ambiguity should be resolved by consulting official program guidelines or seeking clarification from the relevant government authority before proceeding. Question 19. Regulatory review indicates that a real estate agent in New South Wales, NSW, has facilitated the sale of a property where the vendor, without the agent's knowledge, misrepresented the age of a significant structural component of the house. The buyer has now discovered this discrepancy and is threatening legal action, claiming the contract is unenforceable due to the misrepresentation. What is the most appropriate course of action for the agent to recommend to the vendor? Option A. Advise the vendor to ignore the buyer's claims and proceed with the settlement as planned, as the contract is already signed. Option B. Immediately advise the vendor to disclose the misrepresentation to the buyer and discuss potential resolutions, such as renegotiating terms or seeking legal advice on the contract's enforceability. Option C. Inform the vendor that the contract is automatically void due to the misrepresentation and advise them to cease all communication with the buyer. Option D. Suggest the agent independently offer the buyer a small compensation to resolve the issue without involving the vendor further. The correct answer is B. Immediately advise the vendor to disclose the misrepresentation to the buyer and discuss potential resolutions, such as renegotiating terms or seeking legal advice on the contract's enforceability. Explanation. This scenario is professionally challenging because it involves a potential breach of contract due to a misrepresentation of a material fact, which could lead to significant legal and financial repercussions for all parties involved. The agent's duty of disclosure and the enforceability of the contract are at the forefront. Careful judgment is required to navigate the contractual obligations and the agent's professional responsibilities under NSW law. The best professional approach involves immediately informing the vendor of the buyer's concerns and the potential implications for the contract's enforceability under the Conveyancing Act 1919, NSW. This proactive communication allows the vendor to make an informed decision about how to proceed, whether by disclosing the issue to the buyer, attempting to rectify it, or potentially voiding the contract. This aligns with the agent's fiduciary duty to the vendor and the broader ethical obligations of transparency and good faith in real estate transactions, as guided by the Property and Stock Agents Act 2002, NSW, and its associated regulations. It upholds the principle that contracts should be based on accurate information and allows for a fair resolution. An incorrect approach would be to advise the vendor to ignore the buyer's concerns and proceed with the sale as if nothing has happened. This fails to acknowledge the potential for the misrepresentation to render the contract voidable by the buyer exposing the vendor to legal action for breach of contract or misrepresentation. It also breaches the agent's duty to act honestly and in the best interests of their client. Another incorrect approach would be for the agent to independently contact the buyer and offer a partial refund without the vendor's explicit instruction or knowledge. This oversteps the agent's authority, potentially creates further complications, and undermines the vendor's control over their property transaction. It also bypasses the proper channels for resolving contractual disputes. Finally, an incorrect approach would be to suggest to the vendor that the contract is automatically void due to the minor discrepancy, without proper legal advice or consideration of the buyer's willingness to proceed. While misrepresentation can impact enforceability, the contract is not automatically void. It is typically voidable at the buyer's option, and the vendor has rights and obligations to consider. The professional reasoning process for similar situations should involve 1. Identifying the core issue, potential misrepresentation affecting contract enforceability. 2. Understanding the contractual terms and relevant NSW legislation, Conveyancing Act 1919, Property and Stock Agents Act 2002. 3. Assessing the materiality of the misrepresentation. 4. Communicating transparently with the client vendor about the risks and options. 5. Advising the client to seek independent legal advice. And 6. Acting strictly on the client's instructions while adhering to professional and ethical standards. Question 20. Consider a scenario where a residential lease agreement in Sydney, New South Wales, specifies that rent reviews are to be conducted annually, with the increase calculated based on the percentage change in the Consumer Price Index, CPI, for Sydney. The current monthly rent is $2,000. The CPI for Sydney was $115.0 in the previous year and is now $120. 8. If the lease commenced on 1 January 2023 and the rent review is due on 1 January 2024, what is the maximum permissible monthly rent after the review, and what is the total annual rent for the period from 1 January 2024 to 31 December 2024? Option A. The maximum permissible monthly rent is $2,120.00. The total annual rent for the period is $25,440.00. Option B. The maximum permissible monthly rent is $2,102.61 and the total annual rent for the period is $25,231.32. Option C. The maximum permissible monthly rent is $2,080.00 and the total annual rent for the period is $24,960.00. Option D. The maximum permissible monthly rent is $2,100.00 and the total annual rent for the period is $25,200.00. The correct answer is B. The maximum permissible monthly rent is $2,102.61 and the total annual rent for the period is $25,231.32. Explanation. This scenario presents a professional challenge due to the potential for financial disputes arising from a lease agreement's rent review clause, particularly when market conditions fluctuate significantly. A property manager must accurately interpret and apply the terms of the lease, adhering strictly to the Residential Tenancies Act 2010, NSW, and its associated regulations regarding rent increases. The core of the challenge lies in ensuring the rent review is conducted fairly, transparently, and in accordance with the legally stipulated methods, preventing both undercharging, which impacts the landlord, and overcharging, which is illegal and unfair to the tenant. Careful judgment is required to balance the landlord's right to a fair return with the tenant's right to reasonable rent increases as defined by law. The best professional approach involves a meticulous calculation of the permissible rent increase based on the Consumer Price Index, CPI, for Sydney, as stipulated by the lease agreement and the Residential Tenancies Act 2010, NSW. This approach requires obtaining the official CPI figures for the relevant periods, applying the specified percentage increase formula, and ensuring the proposed new rent does not exceed the legal limits for rent increases in NSW. This method is correct because it directly aligns with the statutory requirements for rent reviews in residential tenancies in New South Wales, ensuring compliance with the Residential Tenancies Act 2010, NSW, and the terms of the lease. It promotes transparency and fairness, providing a clear, verifiable basis for the rent adjustment. An incorrect approach would be to unilaterally increase the rent by a fixed percentage that is not tied to the CPI or any other legally permissible benchmark, without proper justification or adherence to the lease terms. This fails to comply with the Residential Tenancies Act 2010, NSW, which mandates that rent increases must be calculated in a specific manner, typically linked to the CPI or a mutually agreed upon method that is still subject to legal limitations. Such an action could be deemed an illegal rent increase, exposing the property manager and landlord to penalties. Another incorrect approach would be to base the rent increase on the perceived market rate without consulting the lease agreement's specific rent review clause or the relevant legislation. While market rates are a factor in setting initial rents, they do not supersede the legally defined mechanisms for rent reviews during an existing lease term in NSW. Failing to follow the lease's rent review provisions and the Residential Tenancies Act 2010, NSW, constitutes a breach of the agreement and the law. A further incorrect approach would be to simply add a nominal amount to the rent without any calculation or justification, hoping the tenant will not notice or object. This is unprofessional and unethical, as it bypasses the legal requirements for rent increases and erodes trust between the landlord, tenant, and property manager. It also carries the risk of the tenant challenging the increase, leading to potential legal repercussions. The professional decision-making process for similar situations should involve 1. Thoroughly reviewing the lease agreement, paying close attention to the rent review clause and any specified methods for calculation. 2. Consulting the Residential Tenancies Act 2010, NSW, and any relevant regulations to understand the legal framework governing rent increases. 3. Obtaining accurate and official data, e.g., CPI figures, required for the calculation. 4. Performing the calculation precisely according to the lease and legal requirements. 5. Communicating the proposed rent increase to the tenant clearly and in writing, providing the basis for the calculation and the effective date, well in advance of the increase taking effect, as per statutory notice periods.